Ah. What was the complaint?
Contempt, my lord. Joseph kindly say the glance page number 8.
Notice is not yet issued.
Notice is not press contempt.
Press admission.
Press.
What was the order and what was the time period?
Order was, my lord, the impugned order of transfer was stayed by your lordship, my lord. Notice was issued, though notice was issued, nobody has appeared. And
Issue police service. And call this matter on 20.
well,
Below that note has to be put. Do you remember the note? What is that matter? Question. Yes. Next. Item 2.
Violence of interim order already complied.
They have complied.
Fine.
We'll drop the proceedings.
They have to take back the petitioner.
Then we have to drop the proceedings, no?
Myla, drop the smile.
Sister, do you have any compliance report with you?
No, Your Lordship, we
Learned counsel for the complainant submits. The petition complaint has become infructuous on account of compliance. First of all, in view of the above, complaint is dropped. Yes. Item 3.
Item 3, my lord. Let's go to
the compliance.
You have complied with this order.
Yes,
What was the order? Bill edition is taken in the light of what has been
not compliant.
The representation was given
Yes, Your
Yes, my lord.
and it is considered now.
No, my lord.
A meeting has been fixed on 21st of this month, Your Lordship, by both by both the parties have been asked to appear before that and to take out a solution, Your Lordship.
Okay. On 21st, deliberately they have put it 21st or what? They have
No, Your
put all
Lordship.
these matters on 20th.
The demarcation of land, Your Lordship, all the stakeholders have been noticed for a joint meeting which is scheduled to be held on 21st of February at 11 a.m. A copy of the letter of 4/2/26 issued by opposite party number 6 has already been filed to them.
See, now they are saying we'll drop the proceeding. In the event they do not do, file memo. Revive that.
No, my lord, I will take the instruction to reply.
Counsel appearing for lovely DG, appearing for the respondent submits that the.
Your Lordship, we keep it to.
No, we'll not keep it. Now on this assurance will be given. In the event it is not done, it becomes aggravated contempt.
Yes, sir.
And you know what we do.
My lord.
Learned AGA appearing for the contempt very fairly submits that the meeting of the parties has been scheduled for 21/2/2026.
Yes, Your Lordship.
26, and that all the steps would be taken to comply with the order dated 11/11/2025 in letter and spirit. First off, with that assurance, the content proceedings are presently dropped with liberty to the other side to seek the revival by moving a simple memo in the event compliance is not done as has been assured now. Ordered accordingly. Item 4. One sentence we should put. In the event compliance is not reported to the Registrar General of this court within a reasonable period, that would amount to aggravated contempt, and therefore aggravated punishment may be levied. Okay. Next. Item 4.
May please. Non-compliance of the order dated 13/8/2025. Time limit is granted 8 weeks. Till today, they have not complied with your lordship's order.
Please notice.
Annexure.
Returnable on 20. Column 20.
Next item also same.
Same order.
Oblige.
Next. Item 6. Put caution vote. Yes, sir.
May I please?
Complied, Your Lordship.
Item 6.
Compliance has been done now.
Yes, Your Lordship.
Sir, last occasion
What
She
you
has already joined her duty, Your Lordship.
joined the duty.
Yes, Your
is
Lordship.
joined my duty, but the earlier my lord have passed. This is the order of transfer, my lord.
What is the order now?
My lord, kindly
Read
peruse
the order, read the order.
last order, sir. Kindly peruse. My lord's last order.
What order? This complaint is against the order dated
Order.
27
11,
21st.
sir.
Let us see the order. Go to the operative portion. So, following directions. Pick up sexual issues, squashing. Mandamus issues. Then places to place you to the same, to post you to the same place.
Same place.
Has it been done now?
Sir, done on 28th. Sir, last of you. Sir.
Has it been done?
Sir.
Paper.
Sir.
Now we are asking, I am asking you,
Sir.
whether the compliance has been done.
Sir, they allowed to me.
Say yes or no.
Yes, sir.
No, English is taught to you. What kind of substandard communication? We are asking, I am asking a question.
Sir.
Whether you have been given posting or not.
Posting, sir.
Yeah. Now further say.
Sir, last order, my lord, I have already given that order that on 28th 1/2026, they allowed me to continue. But my lord, the earlier the transfer order on 7/6/2025 order has been, my lord, has been quashed. So there, initially I approached this my lords and my lord grant interim order, they do not allow. Again, I approached this honorable court in 32197 of 2026. In batch of cases, my lord have passed that order and really. So from that date, they are not allowed. For that reason, my lord of last occasion directed. So why have not allowed this petitioner from that date?
Go to the next order, last date.
Because I have given that order, so 28-1, they have allowed me to.
22. Explain as to why the complainant was not permitted to join duty despite the order, although now it is submitted that order has been issued. Yes, what is the explanation? Why it was not complied with in time? Why till the notice police come there? Why are you not complying with the order? Every order we should have a police.
Your Lordship, I beg apology on behalf.
No, you
We
can't
have
say
now
apology. You are not the implementer. You are only lawyer.
Your Lordship, there must be some delay in the official.
We can't assume all those things. We have made an order on 30 January 2026. Kindly read that order.
Yes, Your Lordship, that is there.
But there, where is the explanation? Let them pay 1 lakh rupees. Yes, that's the way. Otherwise, how to implement the court order? We don't have army, police, nothing. Now time has come that court should have it is another thing. Ask them to pay 1 lakh rupees.
Lordship,
How much? Tell me. We can't leave them like this. He is not, the citizens are not our slaves. They have their independent rights. They have succeeded in the legal battle. Still your officers sleep over the orders. Ask those officers to come before the court now. Call them immediately. Government advocate to secure the presence of contemners immediately, wherever they be, first of all.
complied, Your Lordship.
No, where is the explanation? Why it was not complied? What is that mischief the officers are doing? A section of them, there is a reason to assume they are criminals. Very sorry to say this. Those who do not respect the code, constitutional code it is. If we only do not respect, who will respect the courts? A section of them, I am repeating, a section of the officials are criminals. Not all. There are very good officials, I know. But there are black sheep also. So ask them to come now. They should immediately come. Otherwise, I will direct their arrest and detention.
Your Lordship, will keep it to next week, Your Lordship.
No, not like that. You were already given the time on 30 January. They think all citizens, all other officials are their slaves. That we will not tolerate. They should be made slaves first. We are all slaves of law. Why this happens, I am asking. How many cases, contempt matters are pending before the court? Do you know? Why this happens? Government and government officials are responsible for all this. They should be made to pay. They should be made to ask them now. Go
Your
ask them
Lordship,
first.
ask which we will circulate in the department, Your Lordship. We will forward it to the secretary and we'll make sure that the orders are complied with. The secretary may be directed to that court has
Take
taken
discipline.
displeasure, has expressed displeasure, Your Lordship, and that can be communicated to the department.
The complaint alleges non-compliance of final order dated. Dated 27/11/2025 in time. First up, learned counsel appearing for the complainant submits that after the court notice was issued in contempt proceeding, and after the police stood in front of the contemners, they have complied with the order. First up, this court, next paragraph, this court, why the order dated 30/11/2026 had said as and showing its red on. Okay. Next paragraph. Today, when the matter was taken up, no explanation is offered by the contemners as to the delay proved in compliance, in complying the order. First off, this is a serious lapse. First off, in view of that, the jurisdictional disciplinary authority is directed to initiate disciplinary action against the said officers and submit the action taken to the Registrar General of this court within 30 days, record from this day, filling which it is open to the complainant to seek revival of these proceedings. First, ordered accordingly and complaint proceedings are tracked. Next.
Item 7.
Order dated 8/12/25.
Yes. What was the order?
These three cases were, this order was to allow them to continue in service. They were the assistant professors. They were not been allowed, but they are substituted by another set of contractual employees. That is why we have come before this Hon'Ble Court, and the direction is clause 11 of the content petition. Last paragraph.
Yes.
In the above
They have not
circumstance,
complied with the order.
not valid. Till they not been allowed to join it.
Issue emergent notice, to emergent police notice to the Vice Chancellor,
By sanction in the register,
Registrar, whom you have made party.
both. I have made the all these.
Who were the parties and whom you have now made the parties? Who should obey the order?
Not actually the Vice Chancellor or the Chairman PG Council, because they are under the professional departments. Chairman PG Council is the authority. Copy number 3.
Copy number 3.
Yes, he is the immediate authority.
Copy number 3 is who should obey the order? Now show it from the text of the order.
Order
We can't
of
issue police notice to
university.
everybody. Who is responsible for compliance? He alone can be ordered.
My lord, Vice Chancellor, the authority actually. The authority of the university is the Vice Chancellor.
Issue police notice to the contemners, returnable on 20 February, post all on 20 February with note. Next.
All three, my lord, same.
Right?
All three cases here.
Same.
Same, my lord.
Same.
Item 8.
May I please, Your Lordship? I humbly propose we can come to page 24. The order dated 19/12/2025. Page 24, Mills.
24.
Yes, ma'am. Order dated 19/12/2025. Your Lordship has given a suggestion to which all the parties agreed.
Posting in a nearby college.
Yes. Within 2 weeks, Your Lordship.
5 months or so.
Hon'Ble,
Any reason?
I find the parties graciously agree with the suggestion of this court that the petitioner in WPC number so and so should be given posting in a nearby college, inasmuch as he has to peacefully retire from the service within about 5 months or so. With this proposal, London SGA, Mr. G is very graciously agreeable and assures the court that the said petitioner shall be given posting in the nearby college within 2 weeks. The 2 weeks is expiring on the 3rd January 2026.
Still they have not given.
Plus, what happened? Plus,
They're asking you.
The petitioner again filed another petition and got an interim order. And of course, that has been in the meantime not pressed. And still was handing over charge. Still, charge has not been handed over fully. Again, bypassing your lordship order, giving an undertaking here in the open court
To post you.
Yes, I'm not I am agreed because there is a sexual harassment case. I'm one of the person that is lost.
He was to be displaced.
He was the petitioner.
Instructions, Your Lordship, by this come from first time.
Issue emergent police notice, same order. Ball on. With no. Next.
Item 9.
From the non-compliance of order 239/2015, madam. Phase 10, and your lordship directed to consider the representation within 8 weeks, madam.
They have not done.
They have not done, madam.
They will do now. Emergent notice, same order. Yes.
Item 10.
And 10 and 11 also same.
Call along with each other. 9, 10, 11. Yes.
Item 12.
All right.
On compliance of the order dated lordship 13/10/25, the response of the engagement letter, but it has not issued.
Same order.
Item 13.
Order dated 19/11/25 has not yet been complied.
Yes, same order.
Item 14.
14 also same.
Next.
Item 15.
Item 15 on non-compliance of order dated 3/9/2025, my lord. Your lordship directed consider the representation regarding transfer, my lord.
They are not done.
Not done. Lordship directed to 8 weeks.
Why they are not doing? Do they expect money or what? Why they are not doing when there is a court order? So they have to go with something and please them.
Your Lordship,
Otherwise, there is no reason when there is a court order. They want money. Ask them to stand in front of that Jagannath temple. In This will give.
this is the hierarchy of these administrative decisions.
they are
That is
not-
what that is.
Then
actually-
where is the question?
Yes, Your Lordship.
Nowhere in the country these things happen. Same order. See, on the next date, if it is not done, mere reporting compliance will not do. If there is delay, per day 1,000 rupees. You just inform all your officers. Per day, they have to shell out 1,000 rupees. 50% to the complainant, 50% to our advocates welfare fund. Yes.
Item 16. Non-compliance of order dated 8/9/2005. Lordship has directed to OP3 to consider the representation before but they have not still continued.
Same order. Mr. Mohanty and Behura.
My lords.
See, we have been observing. We have been threatening them. Even then, orders are not complied.
My lords, now today, my lords, out almost 80-90% are complied. My lords, the after notice
But
matter.
you warn your
My
officers.
lords.
Madam, warn your officers, Mr. Mohanty. Otherwise,
we are
per
making
day of delay, even
continuous
after
effort.
compliance, mere compliance does not entitle them to dropping of the proceedings.
My lord.
They have to offer apology.
My
They
lord.
should
My lord.
agree to make payment.
My
And
lord.
with
Mere apology will not help
letter
them.
and spirit, it should be.
And we will direct adverse entry in their office records, in their service records. You just alert your office.
Well.
Okay? Okay. So that at least they should not be considered for next promotion. Yes.
Item 17.
17.
Item 17.
Same order.
Item 18.
May pleasure, lords. Non-compliance of the order dated 2011-2025, time limit granted 6 weeks. Till today, they have not.
Yes.
Item 19.
19 non-compliance supported 5/1/2026. Your lordship directed 2 weeks time to
Same order. Next.
Item 20.
Item 20 petition seeking for regularization and non-compliance supported 28/10/2025. ma'am.
Next.
Item 21.
21. Come on. What is the modification you have sought for? Who appears for? Who has sought for modification? Give that I. Read I. The modification you have sought. Call next week to enable advocates to comment counsel for the petition. Counsel to come and argue. Yes.
Item 22.
22. Review.
26. Foundation of delay of.
But nobody is here. Service is done on the other side. Right? The same order. Next.
Item 23.
23 will also pray for one Passover.
Passover.
One Passover. That's
Next.
Item 24.
One of year number 17254 of 2025 is disposed of as having not been pressed.
Item 25.
Is I received the interim application. I would want to file objection.
When you received the application?
Application, my lord.
26.
October 2025. Some development has arisen in between this time, my lord. I want to file objection.
No. No time will be given. October it was filed.
Yes, October.
Then they-
Thereafter, another order was passed in coordinate bench, my lord. For which, my lord,
No, when it was passed?
okay. In the
Coordinate was, or the order first when? Where is that order?
I am for the petitioner. That has been disposed of.
We have filed that
Intervention application.
intervention with the petition for clarification. I think your lordship, so if he is not filing, short date may be granted to him so that maybe it can be adjudicated by my lord.
Next thing, that's the request of. Yes.
Item 26.
Item 26, 33 and 41, they are all connected.
26 and
33 and 41.
My lord,
40.
my lord, item number 41 is concerned. Pursuant to the lordship's order, they have already complied.
So 41 will talk.
Yes, my lord.
Learned counsel appearing for the complainant submit that there is compliance of the order and therefore complaint be dropped. Ordered accordingly. This is 41.
41 compliance report filed.
That's all.
26,
41. Right. Next. Come to 26. What is 26?
I have prayed for modification,
Modification of the order.
recalling of the order,
Why?
because though I was a necessary party, I was not made party.
You are not made party.
Yes.
For that, you have to file WPC.
I am backed by one judgment of the Honorable Supreme Court.
Before Supreme Court.
I have given this to
Shivdev Singh.
This is
Ajit Kumar.
Asit Kumar. The Lordship will find at paragraph 9.
Paragraph 9.
Yes. It starts from page 471. There is a distinction between a petition under Article 32, a review petition and recall petition. While a review petition, the court considers on merit where there is an error
That was
apparent on the
32.
face of record.
That was under 32 because fundamental rights were in.
Yes, in a recall petition, the court doesn't go into the merits but simply recalls an order which was passed without giving an opportunity of hearing to an affected party.
But this is modified now. This order, this view is modified.
I don't know.
Why? You may not know. I know. 2025. That judgment the other day we said, no? I told you to keep that judgment. Where is that judgment?
We are treating this petition under Article 32 as a recall petition because the order passed in the decision of so and so cancelling certain licenses was passed without giving opportunity of hearing to the persons who had been granted licenses.
That was under
In these circumstances, we recall the directions. However, if anybody has a grievance against the grant of licenses or in the policy of the state government, he will be at liberty to challenge it in the appropriate proceedings.
That is not no longer the good law. Because of this decision. Where is that word? Not Shivdev Singh is treated in that judgment.
I have given my lord.
25.
Chief Justice.
25.
I have taken the ground that he is no more connected with the institution.
My lord,
But exercising fraud on court, obtaining
this is not fraud.
Yes.
He is not a
Completely.
So what is his
He did not argue.
My lord, fraud.
Are you-
He told that I am fraud.
No, not you. You are the client. You are a gentleman. If any function happens in his house, you are the
I'm not talking of the lawyer concern. Your lordship will find in my IA number.
I will start now there is a law that says you have to file the regular petition itself actually. Anyway, you have filed now, since you have taken up the ground of fraud, where you have taken in the application?
Your lordship will find 31381, that is the recalling petition for recall of the order.
What is the ground?
Ground is the exercise of fraud that he is no way connected with the institution. Somebody else has appointed him as president of the managing committee, which institution has no connection with this also. This institution is established by X. Why appointed him as managing committee president?
Why was what?
And producing that, he has obtained this honorable court order to consider their proposal.
Yes, you file objections to that.
Yes, my lord. My
You
lord.
don't want to file objection?
Yes, my lord. I have given.
After arguing, I will not allow. Choice is yours now.
Okay.
Yes. Call after 2 weeks to enable counsel for the writ petitioners to file their objection to the IA. Yes.
Item 27.
But till then, consequences of this order will
not. Let us see.
it will create law and order situation there. Yesterday, law and situation has happened. With armed persons, he wanted to enter into my premises.
My lord, I pray one thing, my lord.
But there is an order. Rightly or wrongly.
That is right.
Consider the petitioners. How many? One petitioner.
One petition.
Petitioner is treat himself as warned against any untoward incidents.
My lord, I pray one thing, my lord. My honest friend.
We are not passed any order. We only say
My lord,
you should treat yourself as
my honest friend saying that this is the war position in that place. It is absolutely wrong.
But without filing objections.
Your lordship may call for the local tahsildar, he will give a report. Or
No,
civil
file an objection.
registrar.
In the meanwhile, we are not.
I'm saying wrong.
We only said, don't create any law and order situation, untoward incident. That's all. Yes. Next.
Item 27.
May I please, Your Lordship?
Yeah.
Kindly see my order dated 30th January 2026 for implementation of your Lordship.
One second, brother. Along with 23 and 41 to be called, 26 and 33 to be called along with each other.
Yes, man.
Huh?
46 is already compliant.
Complaint. brother, 26 and 33 have we got along with each other?
Yes.
Call along with each other.
And 33 notices to go.
In 33,
Trace
it has to
matter.
go.
Trace matter.
33, issue emergency notice. Oh.
Date fixed, 26, next date.
In 26,
A particular
he has to file objections. No?
A particular date may be fixed.
Call Friday after next. Yes. On Friday after next. Okay, not this Friday. So next Friday.
27th, my lord.
May I please, Your Lordship?
Yes.
Well, kindly see the order dated 30th January 2026. After Your Lordship's order, they have not complied with for that in a file IA. Your Lordship directed the last occasion on that 30th January 2026.
Yes.
Kindly see.
Panda.
My lord.
Yes, you see, read the order. Let all people know in the courthouse.
Order dated, my lord, 9/9/22.
This is 30 January 26.
But we have filed in a complaints affidavit yesterday only.
You have filed complaint?
Yes, yesterday only.
Let's say they have complained.
No, my lord.
Perhaps we have not 12/2 means yesterday only.
View that.
The affidavit filed on behalf of the opposite part number 1 and 2. My lord, perhaps we have not served the copy.
Yes, well, I received the copy.
Oh, yes.
They have served me copy.
Then whatever.
No, Your Lordship, after the order passed in Your Lordship 9/9/2025, my lord. Thereafter not proceed with and Your Lordship directed to Education Tribunal, my lord. Thereafter, after Your Lordship's intervention, my lord, they have filed SLP.
They are entitled to. We are not final. Apex court is final.
Paragraph 5 we have mentioned that. SLP number we have mentioned.
Diary number, my lord. Only
diary number, yes.
20th January 26.
20. Yes.
Correct. Now, have you done complaints?
Not compliance.
I'm sorry.
You can go to Supreme Court, no problem. But compliance has to be done. When the order was made, the order to be complied, that order was made on which date?
Your Lordship, my lord. 9/9/25. Your Lordship, kindly say
9/9/25.
9/9/25.
State Education Tribunal OP number 4 is directed to hear and dispose of the subject execution case within an outer limit of 4 months and report complaints to the Registrar General of the High Court. My lord, execution case was directed to be disposed of by the presiding officer, Education Tribunal.
Correct.
My lord, Education Tribunal, the address which was given, there was a dislocation. The address has been changed. It was shifted to some other place. Now, our notice went to that earlier address. I recently communicated to her and ensured that it should be complied with immediately. No, perhaps I have not received any instruction, but it is in the verge of completion, my lord. Only execution case is to be disposed of.
That's fine.
My lord.
He is our judge.
There is
Our judge.
Yes.
So if he does not obey.
No, he has to obey, my lord. Perhaps there is a dislocation, miscommunication, because it has reached late. Because
Reached when?
No. My lord, the new building, it has been shifted now.
In the same city?
No, this is my misleading.
Tosali.
No, they are denying Tosali.
Tosali nahi.
There is a 15 years, my lord.
Function या तोसाली भवन
मुंह पर
हम तो खाली
अच्छा तब शिफ्ट करी नहीं anyway
We'll call it on next Friday.
My lord.
Then you should say something.
My lord, definite. I will ensure compliance by next Friday. I undertake, my lord. I will make personal endeavor.
Learned EGA Mr. Panda assures that on the next date of hearing, hopefully he will report compliance.
Definitely. Grateful, your lord.
Item 28.
28, my lord, similar matter, plus kindly see the order dated 30, last order. Because in that last occasion, I have submitted, despite the London Tribunal passed order of stoppage of salary, till that the state OPs are not complying. You also directed state OPs to comply.
Yes, brother.
Kindly see last order.
Yes, Mr. Panda. Now, see,
99.
Court, the tribunal is flooded with execution petition.
Yes, my lord.
Because you are not complying with the order. Therefore, I will exercise the power under 227 now.
No, my lord, that is right. Your lordship should exercise, but I have to.
We can't wait the tribunal to pass some order. Whatever order tribunal can pass, this court can pass under 227. Kalinga Tubes versus so and so.
The similar matter, my lord, may be posted to 1 week more. I will ensure that.
Friday.
Right.
Yes. Right.
Item 25.
Friday, not Friday. Friday next.
Friday next.
Okay.
Let them comply the earlier. Let them comply the
Yes,
earlier.
we'll definitely.
We'll do something. Wait. Yes.
Item 29, SLP was dismissed. Your lordship, last order, my lord. 31st January 2026. My lord was pleased to pass this order. Lord Counsel for the prisoner submits that the SLP so and so has been dismissed.
Yeah.
My order.
Panda.
Well, my lord. We have complied, my lord. But compliance affidavit we had to file, my lord.
No, if you report compliance, we will believe you. So that in the event not complied, it becomes
Lordship, may
aggravated.
kindly have a glance to this order. I have been handed over.
What was the order? What was the
order is to
execution?
grant that, no, not execution, it was to grant salary.
Case number 3 of 2018. All right. This was a.
This was passed.
Even SLP is dismissed.
Yes.
Well, which WPC 27658 Sadhu Charan Vidya, that matter I am taking up, my lord. 29th, huh?
Yes, 29. That is the same matter.
Same matter, huh? Same matter.
Order in execution at page, my lord, 44 of the writ petition. Your lordship will find.
Before that execution is made, my lord, we are complying from our side. That is the order, my lord. 12 to last yesterday, we have passed that order. Placed funds has been placed 4,66,98,070 has been placed and it is to be disbursed. My lord, this is the
where that fund is placed.
In this connection, the Director Secondary Education Odisha Bhubaneswar has requested to issue necessary instruction to make fund provision to comply with the above order of the Hon'Ble High Court of Orissa. The Director Secondary Education Odisha Bhubaneswar has issued instruction to place fund amounting to rupees 4 crore so and so by Director letter number so and so. The copy of the letter is annexed herewith. In view of the above and obtaining the instruction from the Director Secondary Education Odisha Bhubaneswar, the opposite party number 3 DEO Jajpur has already modified the previous order regarding approval of appointment by this office number so and so in pursuance of the order of the Honorable Court. The copy of the approval letter is annexed. However, as per instruction of the Director Secondary Education Odisha Bhubaneswar, the employees of Sadhu Charan Vidya Mandir Pansupal will be disbursed with their arrear salary with deduction of all statutory taxes on account of income tax and professional tax, etc., as admissible from the claim of the employee and deposit in the state of state as per rules. Further, it is pertinent to mention here that the differential arrear salary bill concerning the employees will be prepared in the HRMS portal and submitted to the District Treasury Jajpur for credit of the account of the employee of Sadhu Charan Vidya Mandir. This requires some time for preparing of the bill to place it to the Treasury for credit of the account of the employee. On the other hand, we have, in principle, we have already agreed, my lord. And we are proceeding to completion, my lord.
No, money fall in the pocket of the employee.
That will definitely go. That will definitely go within 4 to 5 days or at best within a week, my lord.
All this matter.
That's the official procedure, my lord. We are proceeding, my lord. Our bona fide is our bona.
Otherwise, we will implement the last day's order.
My lord.
We will tell not to disperse their salaries.
Yes, definitely. That rigor your lordship may fix. We are bowed down. And we will ensure that before that date we will.
Money should go to the pocket of the employee.
That we are proceeding in that direction only.
Do with your order.
We are proceeding and we will accomplish that, my lord, before that date.
Well, let the survey copy.
Give that copy, Mr.
Yes, yes.
Panda. Share a copy with me. Yes.
Item 30.
One second. If orders are not complied, the contemner shall be personally present before the court on the next date of hearing. Call on 20 February.
20th?
Yes, 20th.
Item 30.
My lord, 27th or 20th?
Which one?
All the matters, your lordship.
I am sitting only on 20th. Yes. Yes.
Item 30.
30.
30, my lord, we have filed an affidavit yesterday,
Saying,
compliance affidavit. Perhaps we have soft copy. My lord, my learned friend is not there.
the copy you have given.
Yes. Compliance affidavit we have filed.
Distress certificate was to be issued. To issue passion the impugned order matter is remitted to the portals of the for consideration of this in the light of Jita notification. And also the rules that obtained this exercise has to be undertaken and accomplished within a period of 8 weeks. Pass over.
We have given appointment, compassionate appointment.
They have given appointment.
Yes, yes.
We'll record that submission.
Yes, 3rd February, on 3rd February, that is the officer.
The operative portion of the order dated 19/8/2025, whereby complainants WPC number 22391 of 2024 was disposed of, reads as under. Next paragraph. Learned AGA, Mr. Panda, specifically submits that in terms of the said order, the compassionate appointment letter has been issued
3/2/2026.
on 3/2/2026.
And we have filed compliance affidavit, e-filed on.
And the compliance report is affidavit is also filed.
E-filed. E-filed 12/2/2026. Yesterday, 12/2.
E-filed.
E-filed.
On 12/2.
Yes. Yesterday.
12/2/2024. First time. The counsel for the complainant is absent, and therefore this court assumes that there is compliance. Next paragraph. In the above circumstances, this complaint is dropped.
Grateful.
Next.
Item 31.
31.
Yeah.
Current direction has been given to consider representation that has been complied.
Counsel for the complainant submits, and learned AGA, Mr. Mohanty, does not dispute that compliance has been already done. Of the order dated 18/8/2025, entered in WPC number 22508 of 2025. First time. In view of CAHO, complaint is dropped. Next.
32.
32. I need some time, a week time.
Learned the first time it has come.
No, my lord, second name. I need a week time, my lord. It they are in process.
At the request of learned AGA, call this matter on 20 February.
Item 33 has been adjourned. Item 34.
Right, now that the all these matters are over, that passover matter.
Take it, pass.
I'm sorry, Lord, I interrupted you.
That's
Item 23.
But as per last observation, Your Lordship had not observed. He complained that appeal memo and other things have not been communicated to him. You have served him copies.
Lord, I have filed here two missed cases. One is for the recall of the order, since I was never issued any notice in the writ petition. I was never heard. And second, that they have filed a false affidavit before this honorable court and taken various orders from Your Lordship, and for which appropriate proceedings should be initiated. Your Lordship may kindly see the first order passed in the writ petition.
2925.
Yes, yeah, 2863. My Lord, in WPC 2863. The first order is of 18th of February 25. My Lord, my registration certificate they had challenged, but
what is the registration? Marriage registration?
No, association, my deemed registration under the Odisha Apartment Ownership Act, when I am the only aggrieved person. But they took only notice to the BDA by emergent notice to special messenger.
Your registration certificate has been.
Yes.
You are not a party.
I was not noticed in the writ petition.
Notice was not issued.
Never.
Not served on you.
Not served. And before filing of the writ petition, they had already filed the appeal. And suppressing filing of the appeal, they filed the writ petition with a prayer that there is no alternative remedy to challenge your certificate, so much it should be entertained.
They had filed the appeal also.
Yes, before filing appeal number 2 of 24, it was filed on 5th of December 24.
5/12/24.
And rate
It's a
was
statutory appeal.
yes.
Appeal under which section? Of which law?
25 of the Odisha Apartment Ownership and Management Act. 2023. And the rate was filed on 24th of January 25. 1.5 months thereafter.
Filed on
24th of January 2025.
Yeah.
I have made a date chart for this. So
date chart you have done.
Yes, at page 4 of my IA at flag E.
Why you notice? How notice was not served? Just look into.
6 to 7 orders were passed. I was never noticed. Deliberately, I was not noticed.
Why notice was not served? When notice was ordered by this court, other coordinate with
Yes, notice was in fact not ordered even. They did not take notice to me.
Notice was notice ordered?
No, not ordered. Never ordered.
No notice ordered
No.
on you.
Only they took emergent notice to special messenger to the BDA, the authority who had issued the certificate. For reasons best known, I was not known. That is on 18th of February 2025 order.
By coordinate judge.
Yes, by the coordinate bench. Your Lordship.
Notice to OP number 2 alone.
Alone. Through special messenger and to list it 2 days after only, on 20th of February.
You were OP number what?
OP number 3.
Why no notice was ordered to you? Those certificates stand in your name.
Yes. And that was challenged.
So let us ask.
And when the appeal was filed before, that is pending. And my lord, interestingly,
they have not said anything about that.
No, so total suppression in the writ petition. Rather, they say there is no alternative remedy. Please entertain my writ petition. They filed an IA to stay my certificate.
When the writ petition came to be allowed.
Further interesting events took place.
No, we are asking a question.
It came to be allowed. My lord, I have to explain something. The appeal stood dismissed before this High Court took up the case. That also was suppressed.
That was dismissed on when?
On 11th of February 2025. Before this notice was
disposed of when?
My lord, WPC was disposed of on 20th of February initially. Giving them liberty to file an appeal.
By that time, appeal was already dismissed.
And they suppressed this fact that my appeal is dismissed.
The same parties had filed the appeal.
Yes, same parties. And then they filed an IA to recall this order in WPC.
And the order came to be recalled.
Recalled, saying that we don't know, appeal was dismissed. And then it was recalled again without hearing me. Then writ was amended, then also no notice to me. Then finally it came before your lordship. Your lordship told you appear before the appellate authority. So complete suppression of facts and a false averment in the writ petition. When their appeal is pending since 2024, why the writ petition was filed in the year 2025 during pendency of the appeal?
Without mentioning about
Without mentioning it. A person who has approached this court with unclean hands, your lordship, is not an.
Yes, who appears? Mr. Yes.
All that said by my learned friend, he is suppressing material facts. He is guilty of misleading the honorable. That the under section 25 of the Apartment Ownership Act, an appeal lies against registration of an association. Now, the appeal which was filed, in fact, was dismissed at a point of time when he was not even noticed. He never appeared there. It was at the preliminary stage. Appeal was dismissed for non-deposit of 100 rupees fees. That's all. He was never contesting there, nor he had even appeared. At the preliminary stage, fresh admission, they dismissed on the technical ground of non-deposit of 100 rupees. That's all. Now it is at this stage, one writ petition was filed. In that writ petition, this appeal aspect was in fact not in the dismissal aspect, was not in the notice of the clients, they could not disclose. Now, inadvertently, that writ was disposed of, granting a liberty to file an appeal. And when they came to know that appeal has been dismissed, they applied to recall that order before this court, disclosing that in fact it's an inadvertent mistake committed by us. Please recall the order. Appeal in fact has been dismissed. give us a chance, we will bring all these facts to the notice of this Honorable Court. They filed an application to recall it. Now, that was also passed before his appearance. So he had no right accrued in his paper since the order was passed.
But no notice was ordered to him.
No, that was, it's an innocuous order, my lord, only to dispose of the appeal. That's all.
If you say no, I can't help you. If you say no, with
I'm sorry, my lord, I said no. I'm so sorry, my lord, I said no, my lord. I'm so sorry. But then what I'm intending to tell is, the writ petition was disposed of with an innocuous order, disposed of the appeal. In fact, the appeal matter, when it came to our notice, immediately we filed an application to recall it. That there is inadvertent mistake. Please recall the order. Now appeal has been dismissed. Kindly reconsider this. Lord, your lordship, to dispose of the appeal, that's all. He has been noticed. He has been noticed.
I may be given a chance to make my submissions in the writ petition. My lord, when the writ petition
was the most innocuous order we have passed. He says,
my lord,
well, the dismissal of the appeal was not known to us, sir. Though he should have stated in all fairness that we had filed appeal. Anyway,
when the writ petition was filed, the appeal was pending.
Correct. Now, how you are aggrieved with this order?
Yes, my lord, because my lord may see they have served me the copy of the appeal memo. There is no mention which is the impugned order. I don't know. I am completely.
You take up before the appellate authority.
I cannot make my submissions, my lord. It will
tell them.
Exercise in futility completely, your lordship. Your lordship may kindly see what has been served to me.
If appeal is incompetent or there are other grounds that all things are not given, you return the appeal memo to the authorities saying that you give that copy of the appeal.
There are 4 annexures.
4 annexures also.
My lord, there are 4 annexures. It doesn't contain the impugned order. My lord, how do you
impugned order?
My lord, that registration is the impugned order and he has obtained it. It is with him.
Under which
he is trying to
I will also go there. Let them say in the appeal memo which is the impugned order. Let them show which.
No impugned order. Registration is the impugned order you have with you.
What you should argue before the appellate authority? My lord. You are urging that point before.
Yes.
You go.
Your lordship.
What he says, Ratna says, if court does not order, I have implemented X, Y, Z. Court will issue notice to X alone. How I can be blamed for that?
No. I am not blaming lordship. Only I am expressing my predicament. Why
that we have understood. How can we punish them on that ground? And what is the order we have passed? The dispose of the.
So,
my endeavor is that the appellate jurisdiction cannot be activated if the original proceedings have not taken place.
That you take up before the appellate authority.
He can only assume the jurisdiction provided there is an original proceeding.
You argue this before the appellate authority.
Your lordship may kindly grant me leave to that respect. Because I have never been heard anywhere. So
anyway, we'll give you full opportunity.
That leave may be granted.
The matter having been heard at length. Come on. Learned counsel appearing for the applicant submit that he should be permitted to take up and urge all the grounds in the pending appeal number
2 of 2024.
2 of 2024.
Before my lord, Vice Chairman, Bhubaneswar Development Authority.
Pending on the file of Vice Chairman,
Bhubaneswar Development Authority.
Bhubaneswar Development Authority, Bhubaneswar. First of all, with this proposal, the contesting OP is agreeable. First time. Thus, the list, the substratum of the list has withered away. Next time, in the above circumstances, the application is disposed of, giving liberty to the applicant as observed above. All contentions of the parties are kept open. Appeal to be disposed of within what period?
May I just indicate, I have filed an objection. His appearance date is fixed on 16th of January 26. He should appear on that.
We will appear. 16 is over now.
16 is over.
You appear before the authority. All right.
Yes, Your Worship. That I will appear.
The appeal to be disposed of within an outer limit of
3 months.
3 months. 2 months.
No, 3 months. 2 months. Because the new BC joined my lord recently 2 days back. So
registration is valid or not. You will look at registration is valid or not.
That's all.
Final within an outer limit of 8 weeks.
8 weeks.
10 weeks. First.
Grateful. Only one, but including the point that the original proceedings have not taken.
All points have been kept open. Exercise jurisdiction directly.
But author says appears to be true. About you. By whom means you are playing. If I want to argue, you are paid for that is another thing. Yes.
Item 34. 34, my lord, your counter has been filed. It will be posted for any day for hearing, my lord.
My lord, last occasion, and Lordship had party ads, though it is not observing the order. In this case, already pleading is completed.
Serial number
34, my lord.
34.
My lordship. Here, my representation was rejected.
Representation for your marriage?
Representation for regular appointment.
Regular appointment.
In fact, appointment. Pursuant to the order.
1 second. It was rejected on which date?
This was rejected on 8/2/2018.
For regularization?
For appointment. It is yes.
My lord, here
Regular appointment.
counter agenda has been filed, my lord.
Yes.
One. It needs a thorough hearing, my lord.
Yes.
Do that.
Yes.
May I pray for next week, my lord? I don't pray for much time because some instruction development is there. 1 week, my lord. Next week, my lord. I don't pray for.
Finally.
That we fixed also.
Right. Yes.
Because
Friday, my lord.
so now he is going to superannuation, my lord.
When?
Because his age is 56.
When he is going to
57.
57?
Yes.
Within 1 month, 1 week, he will become all of a sudden 57.
No, it is already 57. No, he fighting from 2094.
My lord, it is 20th, my lord. 20th, next week. 20th.
Yeah.
Item 35.
My lord, I am seeking review of your lordship's order. Your lordship. Yes. My lord, what has happened in this case?
Who are you?
My lord, I was a party that the opposite party number.
They do not write full cost title in our orders. Final order. Even final orders, you don't write full cost title. What kind of registry? How they should know which other respondents, how to take action against those people in contempt, unless we know who are those parties. Full cost title should be to other court, whatever you want to do. In our court, full cost title should be mentioned, complete.
My lord, I was made a opposite party number 8 in the writ petition. But before issuing notice, there was an innocuous prayer made before your lordship that my representation is pending before the collector, that may be considered. But on this innocuous prayer, your lordship directed this.
Consider.
But though he had mentioned certain things in the writ petition, but he did not bring to your lordship's kind consideration while this order was taken.
That's all. Whether representation was pending or not.
Yes, pending.
It was pending.
Yes. My lord, why I am before your lordship is on two folds. My settlement in SRF case was questioned by this petitioner in the original writ petition before this honorable court. This honorable court directed them to file an appeal. That was also not noticed to me. I filed an application to recall that certain facts have been suppressed, so the order may be recalled. This honorable court modified the order saying that you raise all the points of maintainability before the authority. That was pending and parties are contesting there. He filed another representation before the collector who is a different authority and got an order from this honorable court that my representation may be considered. My lord, can a case or a self-same cause of action run before two courts?
Do you take up that contention?
Yes, that is the reason I filed an application for review. Your lordship permitted.
I am dismissing the application. Or you will permit without permitting. If you want to take up that contention before the parallel authority, because he cannot pursue parallel remedies. You take up that contention.
Your lordship give me that liberty because your lordship directed for consideration representation. I will not be heard. Okay. So if I am allowed to be heard, then it will do.
The matter now submits that if his client is permitted to take up all contentions before the authorities, before whom the subject representations are pending, come on, you would be satisfied.
Yes.
First off, in the above circumstances, review petition is disposed of, granting liberty to the review petitioner to take up all contentions before the authorities who are going to take call on the representations in question. First.
Malad, why I came, there are two reasons. I'm well fully satisfied with the order. Because that came petitioner filed two writ petitions suppressing that fact. That was the reason.
Next.
Item 36.
Similar, here we will file the counter. The notice is. Notice has been issued, Miller. Last occasion, we will file counter, Miller.
Let me take 6 times to file the counter. Finally, first one. Call on. 20. 1 more week.
2 weeks, Miller. We will file counter.
27. 26 already.
26.
Then? 20. Finally. Yeah.
Single bench matters.
Then call after 2 weeks when the this
Title.
we can do Friday next.
Item 37.
37, they have filed a reply affidavit, additional reply affidavit, indicating that when the budgetary sanction will be there, the road will be constructed.
Yes, but
I
without
only
budget,
pray-
how they will do? Money is necessary to lay the road.
My lord,
I'm grateful to them.
his grievances has been complied with. My lord, it was sanctioned and your lordship knows.
To you, sir. But at the same time, it will not be completed before any season. These horizons, that means scheduled caste person, they will be completely in difficulty. That is the whole problem. I think you have not to give a time limit to them.
Compliance is reported.
I am grateful to the court as well as grateful to my learned friend of the state.
Next.
Item 38.
Your Honor, I am for item 38. The police notice has been issued by Your Honor's first order on 22nd January.
You are right.
It is a union. Opposite party, the contemnor is a Union of India.
Union of India. You are for whom?
I am for petitioner.
Complainant.
Complainant.
Union of India does not care the court. Why state itself does not care us and why union should care us?
It is NIOS.
Your Lord, it is on the
person NIOS.
National Institute of Open School, Uttar Pradesh.
Uttar Pradesh.
Possibly notice.
What's the order?
The order is for the rectification of her certificate. The mother's name is incorrectly placed. That is at Annexer 3, page number 14. The mother's name and father's name is same in the certificate.
Not served. Why not served? Received. Sorry, that have not been received. You wait, brother. Service return is yet to come.
Obliged.
Post this matter after receipt of service. Yes, sir. Yes.
Item 39.
Already complied.
39 Miller, here order has been complied. Miller.
Compliance reported by
affidavit also
both the sides. First up, in view of that, proceedings on the complaint is strong. Next.
Item 40.
40 Miller, order has been complied.
Lordship, but the amount has been disbursed.
So it is in process, Miller. We have given this affidavit written 9-2 at Annexer A, Miller. They quantified the amount also.
Lordship, when are you going to pay this?
15 days, Miller.
15 days.
Yes, ma'am.
We'll record that and we'll drop in the event they do not do. Move a memo, it will be aggravated contempt,
Yes,
you
ma'am.
will get more money.
Keeping in view Annexure A, my lord, we have given.
Learned AG, Mr. Mubudi, you have filed affidavit now.
Yes, my lord. 9/2/2026.
Filed affidavit dated 9/2/2026. Annexing the copy of the document dated 21/1/2026, whereby
No, this is my 5/2/2026.
no. Affidavit, now where it is when I'm reading 5/2/2026 at Annexure A. First one, the same reads as under. Next, Mr. Monty further submits that in terms of the above order, payment shall be made, credited to his account.
Yes, ma'am.
Credited to the bank account of the complainant within how many days?
15 days.
On or before the end of this month. End of this month. First of all, in the above circumstances, the complaint is dropped with liberty to the complainant to seek its revival in the event assurance is not kept. First of all, in that event, there would be an aggravated contempt, which would attract more severe punishment.
Item 40.
40 तो कर ली से.
This is
39 complied, 40 also my lord has passed. This is 42
now.
42.
That letter is 21/1.
Item 42.
Yes.
The last order dated
41 days there जाइए रे.
42 is this. When is this put up? No?
Complaint.
11/9/25 in WPC number 246170, my lord. Lordship directed that accomplish the complete within 4 weeks.
Preferably.
Millard, yes, preferably. And in the meantime, we have also filed our so cause reply. Kind of a glance.
Intimated this district auditor comply.
When are you going to complete that? Hereafter, I will never use the word preferably, because you will seek shelter under that.
No, Millard. Kind of a glance to page A/3.
No, I will not glance anything. When are you going to comply with accomplish the task?
Millard,
audit is to be accomplished.
Yes, Millard.
You tell which date you will be accomplishing.
4 weeks, Millard.
Mr. Learned AGA very fairly submits that the process of auditing is halfway through, and that the same would be accomplished within an outer limit of 4 weeks. Record from this day. First, next, in view of the above, the content proceedings are dropped with liberty to the complainant to seek their revival for the aggravated contempt in the event the assurance is not kept.
Yes.
Aggravated contempt, 1 lakh rupees cost.
4 weeks, my lord. Lordship, fix a date, my lord.
We have said that. Next.
Lordship, give a date, my lord.
No, 4 weeks. 4 weeks is ascertainable.
Yes.
Yes.
Item 43.
Order letter 16/1/26.
43, we need some time, Millard.
What was the order?
8 weeks time was allowed in September, my lord. Your lordship dispute of
One second. Leave clean the order. No? Punitive action may follow against the concerned police. Whether service is done on you.
Yes, Millard.
Service is done.
Yes.
When the service is effected, order is dated 11/9.
Here, my lord, the operating part of the order is opposite party to observe the petitioner in any new scheme, public project,
Correct.
with comparable emoluments,
Yes.
keeping in view the qualification long experience of 10 years
Yes.
with an outer limit of 8 weeks.
Okay.
They are in process. For that, I need time, you know.
You will next date you will do that.
Yes, ma'am.
We will drop subject to aggravated contempt.
Yes. May I submit, my lord? Give me some time. By that, I'll come prepared with an affidavit by, I think it will be.
Friday after next, at the request of.
This is my lord 27th.
That will be, yes, 27th.
Yes.
Item 44.
Item 44, my lord, complaint.
Both the sides submit that the compliance has been done. First, therefore, nothing otherwise for consideration. First, in the above circumstances, dropped.
Item 45.
My lords, I have filed compliance affidavit.
Your complaints, give it to me. And go to the, nothing like that. It is only between us, not with you.
My lords,
at all.
my lords,
Give that, what you have done.
we have filed, my lords.
What was the order? 5825?
My lords,
Go to the.
in fact, he alleges that there is disappearance of a sandalwood tree for investigation. It has been investigated with, and he is not cooperating.
What he should do?
No, he has nothing to do. But when he is alleging that,
see the definition of.
my lords, it is investigating through police. My lords.
What happened?
My lords, it is he had taken statements from the officials that there is no existence of sandalwood.
There is no sandalwood tree at all.
At all. Because he was disengaged from the office. He has made some, that is why he was called upon to substance, and CCTV footages were also, it is under process also, my lords.
You suppose if whether his FIR is registered.
My lord.
Registered.
My lord.
After that, suppose the 178 report is filed.
My lord.
If no offense is disclosed,
My lord.
that will be what do you call it in your state? We call it as a fee summary.
Here we call it final report.
No, final report itself is that.
After that, it is open for to go for 1cc complaint case.
Learned AGA, Mr. Behura, appearing for the contemners, submits that the investigation is almost at the completion stage, and based on the basis of the outcome of the investigation, a report under section 178 would be of the CRPC would be filed. This was before the new act came, VNS came before or after?
My lord, BNS.
Under the provisions of BNS. First time. This assures would be done within an outer limit of 1 month. 1 month. First time. With the above observation, the proceedings are dropped with liberty to the complainant to seek their revival in the event things are not done as assured. First time. That would be a case of aggravated contempt. Yes.
My lords, in fact, order was to look into his complaint.
Complaint looking means not just looking into and keeping it.
No, it was already.
It should go to the logical conclusion.
My lord, direction was to collector, and he has directed DCP to registered, and so my lords, no, the responsibility.
No, they should get to the logical conclusion. Otherwise, they'll keep it pending itself.
My lord.
Yes.
Item 46.
46, my lords.
Order not complied. Police notice.
My lords, may I submit, my lords. There was a direction for giving appointment, my lords. It was done. He was called upon to submit some documents, original documents for verification. This is the stage.
Has he submitted the document?
My lords, he has only communicated in 12, my lords.
On 12th?
My lords.
When are you going to issue the appointment order?
My lord, it is already done.
Issued?
Yes, my lord. He
says it has been issued now.
He has to comply.
Received.
Huh?
Notice has not been received.
No, he's saying that we'll.
My lord, this is the report given by.
Learned AGA appearing for the response, the contemner submits that the order dated 25/9/2025 entered in complainant's WPC number 38828 of 2023 has been already complied by issuing appointment order. First off, he adds that the credentials of the complainant are being looked into after
medical verification and
being looked into, and that certain compliances, regular compliances, such as medical tests, etc., are also being done. First one. Next one. In view of the above, there is no reason to continue these proceedings any longer. First one. Proceedings stopped. Yes.
Item 47.
Mr. Anderson. Miller, they have filed the so-called reply mail, but which is not the actually compliance of that your lordship's order dated 1/8/2025.
For extending the benefits to the petitioner as has been extended to other similarly circumstanced employees.
And they did not allow, but they filed the so-called mail by annexing one letter of 9/9/2020 of the School and Mass Education. This is not the order, not the gazette, only the letter. And at the time of admission, my lord, that letter is not produced here and also not produced before the honorable apex court.
My lord, it was disposed of at the first instance, directing us to take a decision in the matter. My lords, what has happened? The rehabilitation assistance scheme was applicable to the aided educational institutions, which were taken away by notification in 2020, my lords. If he is challenging that notification of 2020, he may,
but our order is made.
Similarly, no similar situated person has been.
You should tell them, no?
My lord.
You have to tell the representation, at least your report saying that the order.
My lords, who have stated.
You stated. Give that.
A file.
You have filed it now?
Yes, my lord.
Page 9 of their.
1 second, sit down.
What?
Sit down. Yes. Where is that affidavit? We don't have copy, Mr. Dekura.
My lord.
Give that copy. No, whatever benefit was given pursuant to the order of the apex court, that has been now withdrawn by another order.
It is a letter, my lord.
Letter, order, whichever. Letter dated 1/9/2020. But now what we have said is, whatever benefit is granted to others should be extended to your case. Now there is no benefit extended to others. But therefore you have to challenge that order. You do that. We'll reserve our liberty to you.
Even liberty, my lord.
That's what. Right on. The complaint alleges non-compliance of order dated 1/8/2025, whereby complainant's WPC number 20956 of 2025 has been disposed of in terms of apex court order dated 2/5/2025, passed in civil appeal number 5842 of 2025, arising out of SLPC number 28521 of 2023 between State of Odisha and others versus Jitaluha and others. First up. Next paragraph. Learned AGA, Mr. Behura, appearing for the contemners, draws attention of the court to the compliance affidavit dated 3/2/2026, wherein paragraphs 7, 8, 9, 10, 11, 12. Read as under. Next paragraph. Mr. Behra submits that the question of granting benefit to the complainant would arise on the principle of parity. That is, when some benefit is extended to the parties, to the proceedings before the apex court, in the case mentioned above, and semicolon. The benefit, whatever benefit that was extended to the LRs of deceased the party to the apex court proceeding, wide order dated 1/8/2019 has been withdrawn by subsequent order dated 9/9/2020, as has been discussed in paragraphs 8 and 9 of the above paragraph, and therefore no relief can be granted to the complainant as well. First of all, I find force in this submission. Next paragraph. In the above circumstances, the complaint is disposed of, accepting compliance. First of all, if there is any grievance, it is open to the complainant to work out the same elsewhere in accordance with law, and in that connection, all contentions are kept open. Yes.
It is not the order, but it is the letter.
Anyway, the order or letter. Yes, next.
Item 48.
Same, my lords.
Same, but no copy not served to me.
I'm giving. Same.
The subject matter of this complaint is substantially similar to the one in serial number 46. First off, in view of the above.
47.
The content of the complaint is of
47.
Next.
What? 49?
48.
From the university, writing a so-called minors reply to e-minors of minor threat. In fact, minors may point out one thing: minors directed for disposal of the representation concerning retirement benefits.
So far as the increment is concerned, more increment was has already been sanctioned, and I think within a couple of days it will go to his account. So far, cash benefit, but career advancement scheme, promotional benefit.
What was the order? Let us see. You see, I have been seeing the harassment of the employees at the hands of the universities, colleges, etc. Of course, other departments are also doing it. It's another thing. Why in the university it should happen? If you do not treat the teachers and employees in the educational institution, how can you expect that the country should flourish?
That's I agree with you, man. So,
what is
that, man? Education.
During World War I, World War II, the salaries of all employees came to be reduced, but the salaries of teachers and judges were enhanced, even during World War. That is the respect they show to the teachers community. Why your universities are treating all these teachers as chaprasis?
Now, may I submit one line? Fact remains here in this case, the benefits of gratuity, whatever is entitled to him, we are unable to release it because we occupy a quarter forcibly after retirement.
Are you occupying the quarter?
No, after instruction.
You leave the quarters and they will do that.
Yes, but gratuity will determine.
After instruction. After instruction.
What instruction?
Cutter is leave or not?
If you leave, we will direct. Otherwise, you will drop the proceedings.
After instruction.
Suppose if he quits the quarter, when will you pay?
But
that day he will quit.
The day we will immediately quantify the commercial interest and all these things.
Whatever you want to do, you deduct that money.
Within the day he left it, within 2 weeks we will do it.
No, where he should go without money? You give that money and he will quit. Otherwise, you will direct the police to remove him from the quarters.
Kind of visualize me one thing. Now he is to pay at commercial rate.
How best he will pay whatever rate.
So we'll calculate it on commercial pay. Treating that minus kindly give me date minus till 31st. Minus up to 31st we'll calculate and adjust it and release the gratuity.
Rest of the things you will pay the amount. What was the order?
Annex 1 plus 12 minor.
University to consider the subject of intention, sanction and release the terminal benefits of the petitioner within an outer limit of 8 weeks.
8 weeks.
Failing which the amount would carry interest at 1% per mention. In fact, in Karnataka, we had a great poet and a writer, Kuvempu. Uppalli, Puttappa, Puttappana Venkatappana Maga Puttappa. It's like that. Kuvempu is a national poet, awardee of Jnanapita. He has written one novel, Tabarana Kate, the story of Tabara. Tabara suffered because his terminal benefits were not sanctioned at all. His wife suffered gangrene. He took that wife to the butcher and said, please amputate the leg of my wife. I cannot go to hospital. I cannot incur the expenditure because my terminal benefits are not sanctioned by the government. Same thing I am seeing everywhere, more particularly in your university. Now I will fix on or before 28th or 15th of March.
15th of March.
You will
we will release gratuity amount, adjusting that to what about the due and all these things.
Now whatever amount is paid now.
No, that amount was for increment claimed.
When are you going to do that?
That is within a week, madam.
We'll record that. In the event they do not do, you file revival application. I will revive for aggravated contempt. We will direct the arrested detention of your university. We will not say whom.
I have already communicated the views of minors and the university is a process of the position. Only thing is, may I point out here in this case, minors order. That is at page 11 and 12. Minors directed to consider the representation and release all terminal benefits. We have already disposed of the repetition. But 3 things, minors. So far, the 4 increment, because he held the PhD degree, is entitled to, we are releasing it with 1% whatever minor says. So far as
no, you write down and give it, whatever you want to say. Write down and give. I will replace it in the order.
I will do that. I will do that.
Give that.
Only point I am pointing out the is record.
No, I will direct him to leave
what is over, man.
Otherwise, we will tell the police to remove him with force.
Right. Yeah, that will do one part, minors. What happened, minors also direct to consider the representation so far as the pension is concerned. But he is not entitled to pension.
You say that we have only asked you to pass order. You have not done that.
But Fact remains from 2005. The civil service pension rule has been lapsed. Or none of the employee of the state government are getting this pension lapsed. Now they will go to other pension scheme, MSS scheme and all these things. Just not after that.
Whatever you want to say, we have directed consent.
We have written it in minutes, the so-called reply.
Yeah.
I'm giving it to cheat minors. 1, 2, 3, 4. I will give it minors for minors.
Just give that.
I'll make
pass
it.
over. Pass over. Bring it now immediately.
Item 50.
My lords, here order is complied with, my lords, and compliance affidavit is
complied.
My lord.
Both the sides submit that there is due compliance of the order dated 25/8/2025, entered in complainant's WPC number 22611 of 2025. First off, in view of the above, proceedings are dropped. If there is any grievance, come on. It is open to the complainant to work out the same elsewhere in accordance.
But some money is paid also.
Anyway, if you have some any grievance, suppose interest is not something in accordance with law. In that connection, all contingencies of the parties are kept out. Yes, next.
Item 51.
When money was paid actually, when government was supposed to pay, when it was paid?
My lord. It was paid.
When?
On 27th January 2026.
27. When
very small amount, my lord. Very small amount.
Indeed. Yes.
Item 51. Yes. But it is 7925 has been partly complied. Out of the 3 increments, the losses which are directed to pay 3 increments. And they have, out of 3, they have to 2 increments they given, and another that they are stalled on the ground that the vigilance case is pending. So far as the increment is concerned, they can stop it. 2022 is the vigilance case. Now they have not started. Now they are stopping my increment. They have given the complaints report.
What was the order?
That minor
to look into the grievance of the Krishna.
Yes.
If there is a wrong order, challenge it.
No, that's true. But then on vigilance case pending, only that
I cannot decide here. So we have a limited jurisdiction. Only our order ensuring compliance with our order. Whether the order passed is in accordance with law, I don't have
compliance affidavit.
No, only they have. Let's see that order.
Periodical increments have been granted to you.
Two increments.
Rest of the things you should not note in other
they have ground taken. They have down. They have down. That vigilance case is pending. For that reason, they can stop.
How can we? How can I? Whether on the ground of pendency of vigilance case, whether increment can be withheld or not, you are right in saying it cannot be. But I have no jurisdiction. That you have to work out in writ jurisdiction. I am only contempt court.
That is it. That is the reason they are giving that. The next line.
Learned AGA appearing for the contemner has produced a copy of the order.
Compliance affidavit filed.
Office order dated 6 February 2026, along with the compliance affidavit dated.
Dated, my lords, 11/2/2026.
11/2/2026. 26. First time. The same reads as under next paragraph. The above order office order reads as under. Yes. Next person. The perusal of the order shows that there is substantial compliance of the writ of this court. And therefore, nothing otherwise for further consideration. First, in the above circumstances, the contempt proceedings are dropped with liberty to the complainant to take up grievance elsewhere in accordance with law. First off, in that connection, all contentions are kept open. Yes.
Amount, even the sanction that not in the.
Paid, my lords.
Paid also.
Paid, my lord, I have given receipt.
Your client has not come to you because you will ask for the fee.
Yes, my lord. He'll ask for
that
both.
they will not say. Whenever they receive money, they will not tell that. Except that everything they will tell the
habit of the client.
Yeah. I'll come back within a couple of minutes. Have you served a copy on the other?
No, there's one copy, but just not on my hand.
Yes, brother, appears to be reasonable.
Kindly see my annex 12, man. Page 12.
Now you have to fit the office quarter. They are meant for serving people.
The quarter is issued of Profulla Kumar Swami, my lord. My petition is to Prashant Kumar Swami. Profulla Kumar Swami, kindly see me.
Profulla Kumar Swami.
My lord.
He is Prashant Kumar Swami.
Prashant Kumar.
Only type of copy.
Hello, objection, my lord. Hello, objection.
Take note. This matter is a bit contemptible between court and the contempt. You have nothing to be heard at all. Okay. But this complaint alleges violation of the final order dated 6/8/2025 entered in complainant's WPC number 20329 of 2025. First, the operative portion of the order reads as under last two paragraphs. There is another paragraph. Learned, after service of notice, learned senior panel counsel appearing for the contemners, having vehemently opposed the complaint, now has filed a memo dated 13/2/2026, which reads as under. Next paragraph. Learned panel counsel also submits that since the complainant is squatting on the squatting in the quarters, university quarters, they are not in a position to do anything, and that if petitioner quits, complainant quits, as stated in the memo, there will be no difficulty for complying with the order in question. First, with this proposal, you have to quit that quarters, then only they will do that, otherwise not. To this proposal, learned counsel appearing for the complainant very fairly agrees, and he seeks a reasonable time period for quitting. First one, regard being had to all the had to the fitness of things, the complainant is granted a period of 1 month to vacate the premises, and from the date he vacates, the undertaking given in the memo shall be complied with. First. ordered accordingly, and the complaint is dropped. If undertaking is not complied with, that would amount to aggravated contempt, and therefore liberty is reserved to the complainant to seek a revival of these proceedings by moving a simple memo. First.
Item 52.
And one more point. If there is any other grievance, complainant can work out the same elsewhere in accordance with law.
My lords, item 52, I pray only next week, next 20th.
20th.
Item 53.
Item 53, my lord, that matter, my lord, director for regularization of the service of the employees working in distance education courses in the university. And so we prefer appeal, my lord, the university prefer appeal.
Last time also you said the same thing.
Appeal, we tried on level base and got it listed yesterday. It could not reach. It is in the list today, my lord, so after 2 p.m. fixed.
Call this matter in on 13.3. I think 13.3 at the request of the panel counsel appearing for the contemners. Yes.
Item 54.
My lords, 54. Also, my lords, I pray 20th. Today they are going to comply.
Item 55.
Compliance affidavit has already been filed.
Compliance is done. It is submitted at the bar. It is submitted at the bar that the compliance of order dated 19/8/2025 entered in complainant WPC number 22539 of 2025 has been done. First, in view of the above, the contempt proceedings are dropped, reserving liberty to the complainant to work out his remedy, the remainder of the remedy elsewhere in accordance with law. In that connection, all contentions are kept. Yes.
Item 56.
This is 55.
My lord.
Yes.
Yeah, please, last occasion, police notice was issued as per the noting, my lords, notice was not written.
Service not written.
Not written.
Police to file a report as to why service has not been effected before the next date of hearing. First off, failure would be viewed very seriously, and adverse entry may be made in the service register of hearing police officials. Registry to send a copy of this order to the jurisdictional police by speed post immediately. Carbon copy of this order to be shared with the learned EGA, Mr. Behura. Yes, call on 20th.
Item 57.
57, my lords, compliance.
That order, WPCC order dated January 25, entered in the complainant's WPC number 33244 of 2024. All right? And remainder what got to be elsewhere. Yes.
Item 58.
Yeah, please, madam. But petitioner who has been working as the principal without assigning any reason, his salary has been held up since July 2000.
What is the order?
Order is to, you also have directed me to file comprehensive representation, and I have filed, but you also directed to consider my representation within 4 weeks.
Yeah.
But now in the meantime, 3 months.
Complete.
In that, my lord, in compliance to your lordship's order, the salary, the government has directed the sub-collector to take steps.
July, August, September 2025.
2025, as reported in the representation, madam.
But the rest of the
Till that, my lord, which will be
sit down.
My lord, such release shall be subject to result of the verification of all case-related records of the college. My lord, what it...
No, why only 3 months?
My lord...
3 months. At that time, when he approached, it was 3 months.
Yes.
Subsequently, you mean to say other months, what kind of bureaucratic orders?
My lord, there...
No, you should repair this. We will not agree with this.
My lord, lordship...
3 months. Again, he should come to the court.
No. The problem is that, my lord, there are number of allegations against him. Paragraph 4.
Disciplinary inquiry, dismiss it. As long as you do not do, you have to make the payment. How he should hold his body and soul together?
My lord, lordship.
All this matter. Take this back.
Yes.
Proper compliance office. 20. At the request of so. Yes, next.
Item 59.
Lordship, for the last 30th of January 2026, Lordship was pleased to issue notice to the containers.
Yes. Notice is served on them.
Yes, Lordship. Matter relates to regular activity, Lordship.
I had received a letter, my lord,
saying
that it is not compliance, but they have passed an order that they have sought for clarification from the law department to implement your lordship's order. That is what.
This we don't understand.
My lord,
our order for implementation, our order needs sanction from the government. Law department. Then we will call the law secretary beside us to sit beside us. They can be part of our bench.
No, my lord, it is. Lordship may call this matter next.
20th. Finally.
Yes.
Earlier also final. Yeah.
Item 60.
Otherwise, in every order we should say, for implementation of this order, there shall be no need for anybody's permission, anybody's sanction, etc. from the government side. We start doing that. That will be denigrating the constitutional institution.
My lord.
Otherwise, we will write that also. This order shall be implemented by everybody concerned with the file. Yes.
Non-compliance with the order dated 29/25, pension matter.
Okay. Sarat Chandra.
January 12 issue notice.
Sarat Chandra, compliance affidavit filed, my lord.
Saying what? What is compliance affidavit?
Order, it is there, my lord.
Share a copy with the court. They have copies?
Yes. It does not cover me. I'm getting my lord. I'm sorry. It's a matter relating to that Hemant Chotrai's case. Pension, Hemant Chotrai's case, my lord. That pension matter, my lord.
Even paragraphs are not filled up in the main affidavit at para 9. Paragraphs are not para 9 completely kept vacant.
Still, they have done it. When I study, my lord, it will be subject to outcome of the whatever your lordship will decide in case of Hemant Chandra Chotrai's case. That will be guided by.
What you have done now?
My lord, this order was passed by the Commissioner from Secretary. They have passed this order.
Copy of the order is at
my lord, it was
2/2/26.
Yes. 2/2/26, annexure A by 1/2. My lord, he has been retired from from the service on attaining the age of superannuation on 30/6/2025, being a recipient of block grant employee. The petitioner's post was approved under GIA order 2008.
He is not eligible to avail the pension.
My lord,
you challenge this order. Give copy. A copy is given to you. Okay. This court will, sitting on the writ jurisdiction, made the order dated 18/9/2025 in complainants WPC number 24419 of 2025. First of the operative portion of the order reads as under. Next paragraph. After service of notice, the containers having entered appearance to the learned AGA have entered appearance to learned AGA, Mr. G. First up. The contender number 2 has filed a compliance affidavit dated
Oh.
11 February 2026, enclosing a copy of the order dated 2/2/2026, whereby representation of a complainant has been disposed of. Of course, rejecting the request made therein. First up. The order was to consider the petitioner's representation, and that consideration having happened, there is a substantial compliance with the rate, and therefore no useful purpose will be served by keeping these proceedings alive. Next paragraph. In the above circumstances, the contempt proceedings are dropped, reserving liberty to the complainant to work out his remedy against the order dated 2/2/26 in accordance with law elsewhere. First off, in that connection, all contentions are kept open. You have received the copy?
Yes.
Item 61?
61, my lord, non-compliance of the order 39/2025, my lord.
What?
39/2025.
What the order says? Go to the order.
Annex 1, page 17, my lord.
Questions with of benefits direct to sanction and pay to the petitioner regular pension and all terminal benefits with a interest at the rate of 7%.
My lord, Lordship, give me some more time here.
When with you?
My lord, 2 weeks, Lordship, give me.
Okay. Call on Friday at the request of finally. Yes.
Item 62.
Yes.
Thank you for the glance to the order which has not been complied, my lord. That is 2810.
Pay a cost of rupees 1 lakh.
Yes, my lord.
No appeal, nothing is filed on them.
My lord, that I don't have any instruction. I only instruction that I only received 1 lakh.
My lords, I have instructions to appear in the contempt and I have not received the Okalatama. But however, your lordship's order as regards payment of cost of 1 lakh rupees along with that penalty of 1,000 has already been paid to the petitioner on 19/1/2026.
19/1/26.
My lord, kindly have a glance to the order.
The papers are here also.
Passed.
Yeah.
For financial benefits at page 16.
No, they're saying he's writing.
My lord, kindly
Sure.
to page 16. Two financial benefits are there.
One lakh you have paid.
1 lakh and 1,000 penalty.
1 lakh 1,000.
Because it was not paid within 30 days.
Correct. Then the substantial compliance?
Substantial compliance, since I have instructions to appear and file a so cause, that I'll be filing. If your lordships permit me some time. And that was your order. Your lordship's order was as regards regularizing him. It was a compassionate appointment. So in that view of the matter, very fairly stating that there's a writ of appeal filed by the university also, which I have myself mentioned before the Honorable Chief Justice yesterday, and the memo has been accepted, but it has not been listed.
We'll give 2 weeks. Learned panel Consensus Pattanai, appearing for the contemners, has placed on record 2 letters dated 19/1/2026, both dated 19/1/2026, whereby cumulatively a sum of rupees 1 lakh 1,000 has been credited to the account of the complainant. First, in respect of rest of the compliance, in respect of rest of the order, he submits that the university has preferred appeal against the order dated 28/10/2025 entered in complainant's WPC number 15886 of 2024, and therefore some time be granted. First off, I agree. Next paragraph. Call this matter on 13/3 months. Finally, for reporting compliance, unless the said order is stayed.
Item 63.
Item 63. I have a compliance, my lord.
Compliance. Just looking.
Yes, yes. You please tell. Lordship directed in the above circumstances, writ petitioner disposed of, time for consideration of the subject representation for information and
So he
information.
has been granted an engagement for 1 year.
My lord, that order has been passed.
Brother, just look into that order dated 10/2/2026, day before yesterday, 2 days before yesterday. They have passed that order, see. Go to page 6.
Page 6.
Right.
Final order of the respondent number 2, Collector Hon'Ble.
Yes, ma'am.
Should I place page 7? As per recommendation of the district level.
Post will be taken up out of the remaining candidates of the merit list subject to approval of the committee.
Yes.
Appears to be. Complaint is as to the violation, non-compliance of the order dated 14/10/2025, entered in complainant's WPC number 28338 of 2025. The operative portion of the order reads as under 2 paragraphs. Okay. Next paragraph. Learned after service of notice, the contemners having entered appearance through the learned AGA have have. Okay. First off, contemner number, affidavit is of whom?
It is an affidavit of
opposite party. Which OP? Which contemner?
Collector, my lord.
Ved Bhushana, IAS Collector, District Magistrate.
Vedbhushan.
The contemner, who happens to be the collector, of this collector and district magistrate Kandhamal, has sworn to an affidavit dated 12/2,
my lord,
12/2/2026, reporting compliance of the writ. First up, a copy of compliance order dated 12/2/2026 has also been affixed and enclosed to the said affidavit, wherein the last 3 paragraphs, unnumbered 3 paragraphs read as under. Four paragraphs. Read it. I have just marked it here, right? Yes. In view of the above, contempt proceedings are dropped with a direction to the complainant, the contemner, to accomplish remainder of the task at the earliest and report compliance to the Registrar General of this court. Otherwise, the fee further it will not go.
Well,
again, he has to come with another writ petition. Well, you have to put the flap there. Mark in the table, so yeah.
Oh, sorry.
Yeah.
Item 64.
May I please, Your Lordship?
My lord, your lordship passed an order 17th October 2025. To complete my repentant
The order was, my lord, in the above circumstances, writ petitioner disposed of time for consideration of subject communication annexure 2. My lord,
of the petitioner in writing is 6 weeks.
Yes.
All contentions kept open to solicit.
My lord, this was disposed of on, I had not filed any affidavit, my lord. Morning I got it.
No, whether they have already disposed of the representation.
Yes.
What way it is considered?
It was considered, my lord.
Money compliance is something to satisfy the court.
My lord, no. It is not money.
Yeah.
It is the paragraph 4. So and so ex-BEO, so Puintala, was relieved of his duty on ethics. He applied for leave and leave application was examined and his representation has been considered up to leave up to 37/2025 and his representation dated ethics for extension of leave from method was rejected. The case of the petitioner does not.
My lord, my annexure 2 was to consider my transfer. Since I am having 1 year of service.
This was by order dated 17/2025 made in complainants WPC number 29238 of 2025 had said as under last two paragraphs in the rules of instance justice. Next paragraph. After service of police notice on the contemners, they have entered appearance through the learned AGA, who places on record the order number 3540 dated 9/2/2026 saying that by this order compliance has been done of the writ. First off, the said order is a substantial compliance of the writ issue. First off, if there is any grievance, petitioner complainant has to work out the same elsewhere in accordance with law, and in that connection, all contentions are kept open. Next one. Ordered accordingly and complaints is brought.
May I submit one thing, my lord?
Yes.
My lord, my annexure 2 was for the seeking transfer, my lord.
Next.
In the next
item 65.
Item 65. So cause notice was. I have filed.
They filed a show cause yesterday copy shop.
Yes.
I'm filing my objection, my lord. If my lord see the compliance fact, they are saying compliance. How they, my lord, passed an order in order to just escape from the contempt proceeding?
No.
We are in contempt proceeding.
No, my lord.
Today, have a look today's development.
No, my lord, can you see the?
Kindly see that.
Here, my lord, an amount has been placed before the district treasury for disbursal.
My lord, with due permission, my lord, kindly see for a moment the.
I only request you to read some standard book on law of contempt. This much I can say. There is higher and higher on law of contempt, one of the finest Indian books. There are many books, but that appears to be a good book.
Here, my lord, may I one thing, my lord.
The complaint alleges violation of the order dated 26/11/2020, non-compliance of the order dated 26/11/2025, entered in complainant's WPC number 33631 of 2025. First off, the operative portion of the order reads as under. Next paragraph. After service of police notice, the contemners having entered appearance through the learned AGA have filed
compliance. So cause affidavit, my lord. So cause affidavit.
Compliance affidavit. What is that?
Yes. So compliance affidavit.
Compliance affidavit. Wrongly mentioning, wrongly titled show cause affidavit. Sold to by
the district education officer.
DEO. Who happens to be contemner number
3, my lord.
Contempt number 3. First one. Learned AGA further submits that a sum of rupees How much?
19,100.
No. 19,153 plus there is other voucher also, no?
All right. My salary has been stopped since 2001, my lord.
But we said only consider representative.
I know, my lord. My lord said, in order, my lord, since DEO recommended that
It is on the process, my lord.
My lord,
I am submitting.
they have not yet.
Yes. No. Don't say that. It is under process. It will.
You are paying that.
Yes.
You are paying the salary.
Yes.
If you do not do, next time you file revival, it will be aggravated contempt. Take benefit.
File an IA.
My lord, only thing, my lord, keep it to my lord Friday, my lord. Because my lord, if my lord one page, my lord.
AGA further assures that the amount of salary that has not been disbursed will be disbursed
soon. Very soon.
Within
a day or two.
Within a day or two. First off, there is no reason to suspect this assurance. First off, I did. If this assurance is not kept, that would amount to aggravated contempt. First, with the above observation, proceedings are dropped with liberty to the complainant to seek their revival in the event. The words are not kept.
May I submit one thing, my lord? The direction was not there for consider my representation, my lord.
They are saying they are making the payment.
I am to get from 2001, my lord. Now,
sorry, it will review matters now. Yes.
66.
Lords, this is that matter execution of Supreme Court's direction.
Yeah.
Notice has been served, as I see from the physical record, through police on 2/2/2026.
2/2/26.
Yeah, as it appears from the physical copy, it's not scanned.
Yes, what happened to that execution?
Humbly I pray, my lord, some time may be given because
20th we will have.
20th. Lordship may give. I had, in fact,
22nd, you report.
My lord, yesterday I had talked to them about. They wanted some time. I had also issued them.
97 better.
Yes, I had also issued them a letter to implement the order immediately.
No, they will say we will implement that.
No. They will come up. They will come up with implementation.
We will call this matter. If you assure that this order will be implemented, we will call this matter on 13/3. But assurance will be recorded.
My lord, I cannot assure on their behalf, my lord.
Then we will call this matter on 20th.
20th,
February.
Lordship, 26th, in the month of February, 20th, 27th, your lordship.
Call this matter on 27/2. 27/2. At the request of the AG appearing for the contemners. Yes, if not complete, then
yes.
G, you know what we will do. Yes.
167.
May I please, your lordship?
Yes.
My lord, your lordship passed on order 15th September 2025 in double petition number 23617 of 2025.
Yes.
Seeking a transfer, inter-Dixit transfer. But
yes, Mr. G.
Order has been compliant.
Consideration of the representation, we had said in the right of Varada Rao.
My lord, I had not received any instruction at all.
27th. At the request of. Yes.
State.
May I please, your lordship?
Yes.
The content proceeding at the register of the Dhar University, lords. Notice was issued.
What is served on him?
Yes, sir, brought back as per noting. Police notice is also issued.
No, sorry. I had hold a wrong file. I had hold a wrong file. Compliance is there.
Compliance is there?
Yes.
What is the nature of compliance?
No, not in his case. In the previous case of
another earlier case.
Yes, earlier case. I had hold a, I'm sorry. I had hold a wrong file. They have disposed of the representation, my lord.
What you have done, disposal means how? You have to satisfy us also. Just to escape the Damocles sword, they cannot say, we have considered this, that, etc.
It is a matter relating to transfer, my lord. In case of the petitioner, that he had applied under personal ground category. As per instruction of the transfer notification, no employee shall be transferred from a deficit school to a surplus school, provided this restriction shall not apply to mutual and terminal diseases cases, which is detrimental to the para 3 of transfer notification 25 published by the Department of School and Mass Education for intra-district transfer. And for that, the name of the petitioner was...
So it is rejected.
Yes.
Para 3.
Para 3, my lord. It is rejected.
Telling this will give liberty.
My lord.
In contempt, we cannot decide right, wrong. Contempt jurisdiction is to ensure compliance of the order. Order is consider the representative.
My lord, I have misled this honorable court that there is a capacity of having 69 students, to 5 number of teachers are required. But in their notification,
we can't decide all that. Even if what you say is true, I cannot act upon that because I have limited jurisdiction. It's the contempt court. You file another petition.
My lord.
यदि भूल जाए कोई तो ठीक है, you challenge it.
In WPC, in complainants WPC number 23617 of 2025, this code of void order dated 15/9/2025, this court has said as an operated question. Next, after service of police notice, the contemners have entered appearance to the Cabinet ETA, who has filed compliance affidavit sold to by
opposite party number
contemner number 4, who happens to be district education officer, person. Along with the affidavit, a copy of the order number 1326 dated 11/2/2026 has been enclosed as Annexure 4, whereby petitioners, complainants' representation has a met consideration in terms of the rate. First one. Of course, that order is arguably adverse to the interest of the complainant. And therefore, liberty needs to be, and therefore, proceedings have to be dropped, reserving liberty to the complainant to assail the said order if he so desires. First, in that connection, all contentions are kept open. Next one, ordered accordingly, proceedings are dropped. Next.
Item 68.
68 Miller, the content proceeding against the register of the Dharandhar University, who violate the interim order passed by your lordships, and the notice was issued, but the SR report said the SR is not back.
There was notice is served on them.
Yes, sir.
Notice served.
That report is not with me. That is.
See that. This court wide order dated 22/1/2026 has directed issuance of police notice returnable within 10 days. First off, there is no report of service of process by the police. First off, therefore, which police station?
Keonjhar police station.
The inspector of Keonjhar police station is directed to be personally present before the court on 20 February 2026 at 10:30 a.m. to show cause why action should not be taken against him. First one. Next one. However, in the meanwhile, if service report is filed with the registry, his presence shall not be necessary. Next.
Item 69.
Call on
69 mile.
Yes.
Your lordship kindly see last order that is dated 30th January 2026, the petitioner is a retired person, my lord, is not really, the opposite party is not condemned or not.
Service happened.
My lord?
Service.
He is retired from service.
Service of notice on the other side.
No, I have not.
That you have to ascertain, na? Yes.
Service not.
GPF amount is not written.
Service item is not written.
Same order. Notice was issued when? See, this court, while the order dated 31/20/26 had said as a next paragraph. The service of notice is not reported by the jurisdictional police. Which police station?
Perhaps Bosta, my lord.
In view of that, the inspector of which police station?
Bosta.
Bosta police station.
In the district of Balasur. In the district of Balasur.
So he is directed to be personally present before the court on 20 February 26 at 10:30 a.m. First up. However, presence shall not be necessary if service report is in the meanwhile submitted to the registry. Column. Yes.
Item 70.
70. There is a complaint.
It is submitted at the bar that the order dated 8/12/2025 entered in complainant's WPC number 34870 of 2025 has been finalized. First, in view of the above, proceedings are dropped. If there is any grievance, first off, remainder of the grievance may be worked out by the complainant, if any, in accordance with law.
He already joined, my lord. He joined.
Then this content is not.
He joined, my lord. On 10th February,
yes,
2026.
71.
71, 72 complied with. They have rejected my claim. Your lordship granted liberty to SL that rejection order.
This folder.
We have filed complaints also.
Yeah.
Item 73.
But say number. This WPC. Yes.
Partner.
But
Well, it is a.
we have it next week.
Next week.
Because instead of next week, we'll have it on 13th March. No, not 13th or 13th March will be. 13th March. Yeah.
Item 1 mention, my lord. Item number 21.
21.
My lord, there is a modification of order dated 14/10/2025.
21.
My lord. In paragraph number.
I think order is already signed.
This page. This bench particular these, my lord just said.
Lordships, the regular bench has to be mentioned. So then there will be confusion at the end of the registry also. And since regular bench was put
there.
Pension matter.
When Monday is visiting.
Yes. Item 1.
Yes.
We have prepared the index and the phlegma sheet for our reference. Because we asked the person who has carried the receipt from the office of the district judge.
There's been some discrepancies in the marking, Your Lordship. I have phlegma 3 important documents, Your Lordship, here. One is the,
you will place that today or take time?
if your lordship may give us some time to correct it, because we've made a rate chart, but it seems that some of the.
Documents, so that he knows that these are documents you are relying on. Because again, another answer the process.
If I may just place with your lordship, there are 3 documents that we wanted to show.
So, you again look at it, prepare it completely, then you come. Because adjourning it again, it can't be taken up on the next day. It have to be when these base functions next only.
Yes, yes, yes.
When we see Mr. Saraj Chandra Das for the petitioner, Suman Patnaik for the opposite party. The matters will be listed when this bench functions next. In the meanwhile, the counsel for the petitioner, if he wants, can peruse the documents contained in the original files proposed to be produced by the opposite party state. Lord DG submits that she shall prepare an index and flag mark the relevant pages, and if necessary, she will obtain instruction regarding the documents from the appropriate court.
Item 2.
They have prepared especially petition for the Supreme Court dismissed. All the SLP, different SLP have been filed, all were dismissed. In one of such cases, that is the CONTC 356 of 2020.
When dismissal happened?
Dismissal different date, of course.
Multiple SLPs were filed.
Yes.
And on different dates they have been dismissed. Latest dismissal is of which date?
That's the last one. 16 January. Yes, 15/12/2025, SLP was dismissed. It's in the main case. And the another case is 19/9/2025. The first matter that was dismissed on 19/9/2025. See that. Yes.
What was the order?
Order of division, the single judge has rejected the application. The division bench allowed the application with a direction for inclusion of the name of the petitioner in the final merit list, which was published on 5th August 2024. Onward action for appointment.
Yeah. Yes, madam. What do you think?
Lordship will ask the department to proceed with your lordship as soon as possible to implement the orders, your lordship.
Division bench judgment was passed way back in 25/2/2025.
Yes.
For compliance, your lordship, we will.
Of the SLP, we have to comply with it.
Yes, yes, your lordship.
When
Allow the
will
department.
you comply?
6 weeks. 6 weeks time, maybe.
No, you tell the date when you will comply. We will record that in the event you do not comply. Then it will be an aggravated contempt. They will be entitled to seek revival on aggravated.
Your lordship, it's a series of contempts, your lordship. Series of matters, your lordship.
Correct. But for all of them, one order is sufficient.
Yes, your lordship. 6 to 8 weeks, if we are given, your lordship will try a level best to comply. 6 to 8 weeks.
What is that?
Individually, they have to be seen. You have to be put in the provisional level, your lordship. Individually, the records have to be
we have said
corrected, your lordship. Individually, they have to be put in your lordship. Series, your lordship.
Dates to be introduced.
2 has a series, your lordship. 6, 7, 8, and other matters are also there. Similar matters, your lordship.
Within 6 weeks, you have to do.
Yes.
And in the event it is not done, see, on their assurance, we are dropping the proceedings with liberty to revive them for aggravated contempt. Then only they will be threatened. Otherwise, they will not do.
But what my lord,
Aggravated contempt.
but my lord friend says that series of cases, but
No, makes
all
no
the
difference.
cases.
It makes no difference.
Please you start with the SLPs where disabilities.
Yes.
That's what. No, once this other cases also have to do because Apex Court will not pass different orders in other matters.
No, but different SLPs were filed, your lordship, so they have to.
All will be dismissed.
All will be.
Been already dismissed.
That is.
The complaints in these matters alleges non-compliance of the order dated 25 February 2025. First off, the senior advocate appearing for the complainant submits that the state order on being challenged before the apex court in various SLPs has attained finality. The said SLP has been negative. First off, next one. Lugnet EGA, in all fairness, submits since the matter has attained finality at the hands of the apex, at the level of the apex court of the country, the order dated 25 February 25 entered in the complainant's writ appeal would be implemented in letter and spirit within an outer limit of 8 weeks. In 8 weeks.
Obliged.
First off, there shall be no waiver for extension of the period. First off, in the event the order is not complied with, that would be a case of aggravated contempt and therefore will attract aggravated punishment. Stroke 5. First off, the above observation, these proceedings are dropped for the time being with liberty to the complainant to seek the revival if the words given to the court are not clear. First.
Item 3.
Lord, item 3 is also similar, your lordships. Item 3 is also same, Manoj.
Same order.
Manoj.
Same order.
3, 4, and 5.
3, 4, 5. Same order.
Lord, 6 also.
3, 4, 5, 6.
Yes, Manoj.
6, 7, 8.
No, my lord, 7, my lord, there is one problem. My lord, the state has not preferred an SLP till date.
Then it makes same. No.
Yes. But what they have not preferred.
Other matters like
That line has to be, or it has to be modified. In some matters, SLP was filed and they have been dismissed.
No, my lord, all the matters.
And listen, Mr. Saurabh, you are leaving us behind.
My lord, I'm so sorry.
7, what would be the order? Because if you say that the SLP has not been filed, there is a scope for filing. They filing SLP. Or we can observe that since in other matters,
Yes.
SLPs have been filed and they have been dismissed, this the update should comply.
Grateful, man.
That's
Grateful, man.
7 is not dialogue. 7. 8 is the sort of.
8 is also the same.
8 is
The
also.
first order, my lord.
First order, please. My lord, item 14 also can be disposed of in the same lines.
Up to 18.
No,
14
up
to
8.
8.
Only 14, my lord. One more item, 14, similar, my lord, that can also be disposed of in the same lines.
which my order, my brother's order, which order?
Sorry, my
7 or other than 7?
No, my lord, item 14, my lord, is similar, my lord.
Will be dismissed or?
No, not yet dismissed. This one is not yet dismissed.
See,
Simply not dismissed.
No, not yet dismissed. They have been granted 6 weeks time to remove the defects. But till date, the
anyway.
14. The SLP is pending. And the removed defects have not been removed.
That is
grateful, Manoj.
13, Mr. Bhatt, you are saying also the same one.
No, my lord, up to 8. I mean 6, 7, 8.
Up to
That
8.
is your lordship. Exactly.
Anyone of you, one thing is possible. 13 one order. 13, 15, 15.
different orders.
Yes. Okay.
13 is different.
All right. 9.
Item 9.
I am on behalf of Mr. Vera. I am for the appellant. Lordship, after dispose of the appeal, as yet I have no instruction.
No, what is that? It matter is posted for what?
I have filed an IM.
Extension of time.
Order number 5, dated 25/8/23, the matter was directing the appellant to pay 24 lakhs. That was the order of the. By code of that, order was there to dispose the same. So accordingly, they have paid only 12 lakhs. Another 12 lakhs is still there.
But who has filed extension of time?
No,
you are the decree holder.
I have not filed.
You are the beneficiary.
Yes, decree holder.
So you have filed extension of time.
No, your lordship.
But after not filed, the other lawyer has filed.
Yes, your lordship. Another, we have no instruction regarding this.
That is contrary to Supreme Court.
My senior name may be deleted from clause list.
You agree for the other lawyer to appear?
Yes, your lordship.
Have you given consent?
Yes, your lordship.
So who is the other lawyer? His name is mentioned.
I know that.
That also is also. What's your name, sir?
Jyoti Sagar, sir.
Jyoti Sen.
Sagar Swain.
Sir, Mr. J. Jyoti Sagar Swain for the petitioner. Mr. Ramdas Achari for the opposite party. I have go to 7 of 2023.
No. But if we give that extension, we can make it.
And I get 130 of 2024.
130.
You are fine.
Yes.
Can you taken up together? I want to with the husband data. For payment of amount directed. Also directed by this court or
No, by the family court that has been confirmed by 24 lakhs. 24 lakhs.
Decree to be straight by the confirmed by this court in that day. So Jyoti Sagar Swain, when counsel appearing on behalf of Jyoti Krishna, who was appearing in the appeal on behalf of the appellant, disposed to the matter. On which that, who not to resource to place the imbue. Also, translate on duplicate copy. On duplicate copy. That issue to the Krishna. My mission is this one. Notice to be issued, notice that we issue to the by working days. 5 working days. The notice be made returnable in today's 27 February 2026. The matters have been listed next when this bench functions. Or will be available. Then the other IA 130 of 2024. It is submitted by Mr. Achari that how much the amount has been paid after 24? 12 only has been paid.
Only 12.
Submitted that 12 amount of rupees 12 lakhs has been paid by the appellant. And the rest 12 lakhs remaining due. In view of the order passed in the connected IA, as above, the matter stands adjourned to be taken up along with the other IA when the bench sits next, when this bench sits next.
Lordship, the name of my lord senior may be deleted. Yes, lordship.
We should not. Because deletion is a problem also.
Yes, lordship.
Look at the Okalatnama, it does not include that. I noted your submission.
Shall I call this name?
बाहर का कौन उधर से बाहर चले send someone to call you. Yes, sir. Not presenting, inside the not another, no other.
What is not available, the notice could not be issued to the soul of the
Or dated directly registered to. Which order we directly registered to? 1712.
Registered post is not available, na? Yes, sir. Fresh steps by speed post, as requested by the
Post with registration.
with the registration.
Registration proof of the language they have amended, is it notified?
That's it. Filed a IFR amendment of the first title, the correct address of the.
No, let notice.
That is. The repeat petitioner has liberty to take notice in the newly discovered address.
Item 12.
Item 12, Your Lordship, I'm seeking an accommodation, Your Lordship, on the round of Senior Counsel.
The senior advocate is on, have you told it?
Ms. Rath, she is not well, so she has requested that personally.
All this matter when the
Next
attention as requested at the bar.
Item 13.
Item 13, this is a basic cases where before the Supreme Court, the matter was dismissed. Again, a review petition was filed, which is pending before the Supreme Court.
That makes no difference.
My lord, that's right. I'm praying for some time, my lord. Lordship may give me some time so that.
The board has already passed order.
Sir. My lord, Lordship may give me some time so that we shall take steps to implement.
You tell us when you are going to implement. Review is no pendency of review is no ground at all.
No, their lordship filed disposing of the petition, my lord. Their lordship have said that the circumstances, they have said that the counsel was not filed. But it is not a fact.
The order has been placed. Because my lord, the Chief Justice has directed one matter to be listed in the other bench. You are directed to produce the date on which you filed the counter and whether you have filed counter before this court.
My lord.
Your answer is very fair that we never have.
No, that is wrong. It was filed under
Question of
before.
Yeah.
That was wrongly submitted by the AOR there. But that's why we have filed a review application and it is pending, my lord. So I humbly pray, my lord, Lordship may call this matter in the next sitting. I hope and trust that matter will be listed before the Honorable Apex Court.
Mr. Mishra,
Sorry, man.
what do you say? He made certain submissions. What's your response?
My lord, my only submission is that on 14/11/24, the matter was taken up by Honorable Supreme Court.
No, that he has already said that. Dismissed also. Now review is filed.
My lord, on the ground of, because here, my lord, what is happened? The poor persons were getting 500 rupees. That also not being paid. They are also directed for payment of minimum wages. But they have been brought up to they have been dragged up to Supreme Court also, but nothing. And there was a judgment. That judgment has been implemented. There again another judgment has come. That judgment now they went to Supreme Court. Supreme Court also dismissed. And counter resented, everything was filed, everything was there on record. So if based on that, my lord, and you are supporting his submission. Sir,
yes.
So resender,
If you agree that counter was filed and Apex Court did not notice it, they are more.
They said no. High Court. I am speaking of the High Court. High Court. Sir, Supreme Court has dismissed the SLP that because they could not produce the counter filed before the High Court. That is but that is a wrong submission. Based on that, even if that is a worse for Supreme Court also. In fact, the state had not filed any counter affidavit in the consent position, which is under challenge before this court. In the office of this matter.
That is what I am submitting.
Just read the line before that. You will get the context. What you just now read, the line before that.
when the case is taken up, we could elicit from the government counsel that in fact the state had not filed any counter affidavit in the concerned proceeding, which is under challenge for the court.
That is not correct.
That is not correct.
Therefore, they have moved the review now. So we'll give them 4 weeks.
Yes, madam.
In the meanwhile, let them say what is.
Let them
All this matter.
after 2 years.
Near about 1.5 years.
1.5 years after they are filed. Anyhow, but your ultimate
After 4 weeks, at the request of the AGA. Final. Final. Yeah.
Item 14 has been disposed of. Item 15.
In this case also,
They have taken time before the Honorable Appeals Court to comply the order within 3 months. And it was also directed that the Municipal Secretary will file an affidavit within 3 weeks, so that stating therein that they will comply within 3 months.
3 months or over when? 3 months.
From the date of filing of the affidavit.
3 months they have given.
Oh, not given.
And it was also observed.
That is made for
pending.
It was also observed that there is no necessity of continuing the contempt proceedings before this court, and also held that if they will not comply that, then that would be revived. Therefore,
I appreciate my so-called base 12.
No, see, you are both of you are on the same page.
Yes.
He is saying the same thing, I think.
Now, what should be done in the matter now?
Now, my lord, I
proposal. So that we will consider.
My lord,
I filed an application for IA for clarification and modification order for extension time, or lordship kept in abeyance as per my lord till period is over.
No, Supreme Court has said that for 3 months.
Then after 3 weeks,
after 3 weeks,
take up this matter.
I have to file an affidavit.
Call after 4 weeks.
Yes.
At the request of the bar.
Yes, ma'am.
Yeah.
Item 16.
16, my lord, I have already complied with my lord.
Complied.
Let's see.
Connected matters, I have entered my appearance. My name has not been indicated.
In which? In this one?
Yes, my item 15.
Okay. Registry to show. Yeah.
देखिए देवे.
Yeah, file is.
Complied.
Yes, my lord.
Is it complied?
They're saying that it's compliant. They have generated one order. Only thing I need to submit before your lordships, that they have made they have allowed, subject to an SLP they have filed after your lordship's order. Just I needed to bring to you.
Our order is subject to SLP.
AGA appearing for the contempt subjects that the order in question has been complied with, and therefore proceedings be dropped. First term. Learned counsel appearing for the complainant does not much dispute it. First term.
Benefits have not been
in view of the above, proceedings are dropped. If there is any grievance, it is open to the complainant to work out the same elsewhere in accordance with law. First off, in that connection, all contentions are kept open.
Oblige, my lord.